Hallelujah! It's 4:41 p.m. Yay! Guess what? Something I have not been able to find for years is finally available. It's literally all I did was copy and paste it from the spreadsheet. I've done this so many times. Alas, I've never been able to find it until just today. What did I just find? Is this accurate? Or was it ex post facto overhauled? United States versus Harvey. 560 Federal Supplement 1040. Southern Division, Florida, 1983. Apparently, it's concerning a proceeding that took place on August 30th of 1982. But lo and behold, what did I find? On motion to vacate restraining order, February 14th, 1983. 1993, 2003, 2013, plus 5 is February 14th, 2018. In Florida! Oh dear. It concerns defendant William Joseph Harvey, Thomas Sykes, and Dennis Kay. The understanding I had is that there was, in this case, specific argumentation regarding consideration of marijuana as a dangerous drug, or rather, marijuana as a narcotic. Now, in my original motion to the Texas Court of Criminal Appeals, which was itself based upon a denial or done after a denial by the Supreme Court of Texas for lack of jurisdiction, which I understood was because it was actually a criminal proceeding, I had cited another case that had within it discussions of considering marijuana a narcotic, or rather a dangerous drug that had implications concerning narcotics. I understood that U.S. versus Harvey, as of May of 2017, I understood that U.S. versus Harvey had an argument that was comparable that could potentially have supported. But I hadn't even found the case. I hadn't even looked through it before, right fucking now, because I couldn't find it. I wasn't going to do anything with it until after the court had set a hearing and or the time frame came for an official explication, and they had provided me with a safe process by which to submit evidence. And every time I've tried looking for it in the last 4 years, I haven't been able to find any information about this specific case. U.S. versus Harvey. Now, on the law site it's on the website it's on, it's possible that it's been ex post facto tampered with. Or was it? Did they literally hack into my work and steal it and intercept? Because what does it say right here? Title 3 intercept. Regarding authorizing the interception of exhibits, evidence, and the interception for an additional 30 days of other evidence, most of which is between October and December of 1980. Ordered and adjudged that each and every motion to suppress the Title III oral intercept and the evidence derived therefrom, and including motions to suppress the Florida Chapter 934 wire intercept and evidence derived therefrom, addressed by each and every defendant entitled to do so by law, is hereby denied, each respectively for the reason hereinafter set forth. Did somebody think they were going to be fucking cute and name a hurricane Harvey as a way to deflect from addressing an argument around patterns of distribution, or rather patterns of illicit distribution connected to efforts to habituate people to patterns of acquisition, consumption, storage, and distribution with the intent to normalize them to cooperation with criminal activities? See, in the summer of 2017, this was a different argument than it was by February of 2018, which is why it needed to go directly to the Department of Justice in Washington, D.C., which it did, and was at least arrived at the Department of Justice office in Washington, D.C. on February 12th of 2018, right? But did somebody say, well, we're going to teach the bitch a fucking lesson? How far along are you in this educational paradigm, guys? Is this accurate? Is this an accurate understanding of this supplement that's dated for, is it actually dated for February 14th of 1983? Was it literally dated for 35 years before you orchestrated a school assassination that, among other things, killed 3 members of the JROTC and tried to pin it on a boy that you guys had tortured? It could have been prevented. No. How can I put this? It was not appropriate to cover up for people intentionally orchestrating murders of school children in order to try to extort me into agreeing to cooperate with narco-terrorism. And this narco-terrorism, by the way, now involves smuggling nuclear and chemical fucking weapons while engaging in premeditated acts of murder. See, here's the problem. I didn't get to read this case. I was more concerned with the arguments around what constituted legally labor racketeering in U.S. versus Flynn. But I hadn't been able to find this case, so I didn't know that part of what was going on here was that it involved charges that included drug-related offenses that also described bribery of public officials, murder, stolen car engines, and conspiracy to commit murders, each constituting a separate violation. Not only that, the defendants were involved with a towing company. Like how you let me get kidnapped by fucking terrorists who got a fucking bribe from the goddamn fucking insurance commission when it was in default to me. What do you expect to be a reasonable response to this? What do you expect? Because I haven't even gotten to what could potentially have been the considerations of this case that would have been appropriate, which is somebody made an argument concerning consideration of marijuana as a dangerous drug, i.e. a narcotic. Defining narcotic as dangerous drug, defining a dangerous drug, and then defining how marijuana constituted a dangerous drug that describes what a narcotic is. So it could be considered when it came to patterns of acquisition regarding dangerous drugs and how they qualify as predicate crimes in a RICO conspiracy. I didn't get to find this case to make that argument. I still haven't found it. I'm shocked by what was supposed to be the elaborate ritual in the stead.